Good afternoon, everybody. Thank you for joining us for another webinar. And this is the third one in the series that we've had recently talking about H-1B visas, H-1B visa lottery, the selection process. And now we're moving on to what are your alternatives and the green card pathways. So that skipped far there. Let's go back to slide 2. So today we're going to talk about the next steps and your alternative options to the H-1B. If you were not selected in the H-1B visa lottery, what does that look like? Cap-exempt H-1B visa options, which are a great option that people often overlook. And there's some different angles with cap-exempt visas that people aren't often familiar with. The long-term U.S. immigration strategies and some upcoming webinars we have. Now, the next steps, if you were not selected in the H-1B visa lottery. Now, this is important to understand. So they did the first iteration of the H-1B lottery already, and those results were posted. Now, and before I get started, I think it's been said in the chat, but if you do have questions throughout this webinar, we love questions. So please submit them. We'd love to answer your questions at the end of the presentation. So if you do have questions that you would like us to address, please ask them. So once the lottery was run, they notified all of the individuals that were selected in the lottery. Now, what is confusing about this process is only those selected were notified. So if you were selected, you get this, hey, congratulations, here's your selection notice. Well, if you didn't get selected, your account remains as not selected, and it just sits there. And there's no notice that says, hey, we ran the lottery and you weren't selected, but you might be selected in the future. You just don't get a notification. So we get foreign nationals and their employers saying, hey, did the lottery happen? We didn't hear anything. And then you get the ones that was, hey, we saw we got selected, now what? Those ones are excited, they got notified, but the other ones are confused. What happens now? I didn't hear anything. Well, that's the way it works. If you weren't selected, you're not going to hear anything. And it could be a several weeks to months before you officially receive a non-selection notice when they officially close the H-1B lottery. It has not officially closed yet. They did the first running of the lottery. What's going to happen now is 90 days, people will have an opportunity to file the H-1B petitions based on that selection. And if they don't go forward with the selection, those numbers get thrown back into the lottery, and then they'll do another round. Actually spoke to somebody yesterday who was selected in the lottery, doesn't want the lottery selection. So he's telling his employer he doesn't want it. That's going to go back into the bucket. So there's at least one more that I know of personally that's going to be in that rerunning of the lottery. So that's going to happen. USCIS will announce if they do another selection of the lottery, and they will do that until all of those numbers are used up. In some years, you get 2 or 3 runnings of the lottery. So if you have not yet been selected, it does not mean you can't have a potential selection in an additional running of the lottery. So it's not the end of the road yet. If you haven't heard anything, we'll keep monitoring your USCIS account for those selection notices until you officially receive that non-selection notice once they officially close the lottery. So very important to understand. Now, if you didn't get selected in the lottery and you don't eventually get selected, well, then that's the time where you need to start considering whether or not you qualify for another potential work visa in the United States. Also, it's very important, maintain your status. Stay on top of it. So if you have OPT, CPT, or whatever your visa status might be, and it's coming to an end, then you need to make sure that you change status, depart the country in a timely manner, but make sure you maintain your status in the United States so that you don't jeopardize your ability to live or work in the United States in the future. And it's very important to discuss options with your employer and an immigration attorney. There's many different options that are available potentially, depending on your experience, your education, the role that you're filling in the United States, your citizenship, your country of birth. We are going to cover four of the main ones that we see, but it doesn't mean that these are all of the options, because they are not. For example, we're not going to go in depth on E3s for Australians, which is another alternative to an H-1B, or E2 investor visas. That's another alternative potentially if you want to invest or start a business in the United States. And there's also H-1B ones for Chilean or Singaporean nationals. So we're not covering those specifically, but there are other options that we may not cover today in this presentation that might pertain to you. So it's important that if you don't see yourself in one of these categories we're talking about, that at least have that discussion with your employer and an immigration attorney to understand if you have any other potential options. And I failed to announce I'm here with Rebecca today. She's one of the associates here with Richards and Drusick, and I'm Jeremy Richards. So at this point, I am going to turn the time over to Rebecca, who will take it from here.
All right, so like Jeremy said, we're just touching on some of the main alternative options available for those not selected. So we're looking at the TN visa. This is specifically for Canadian and Mexican professionals under the USMCA, which was formerly NAFTA. The L1A visa, this is for intracompany transferees. The O1 visa, this is reserved for individuals with extraordinary ability. And if you're a student, you might still be on F1 status. You can possibly extend your employment through OPT, CPT, depending on your situation. And then there's also the option for cap-exempt H-1Bs. That's if your employer that you're applying through is a university or a nonprofit research organization. Now, to go a little further into these options, so for the TN, like I said, it's only for Canadian and Mexican citizens. So if you don't fall into that category, you're going to have to find another option for you. With TNs, there's a specific list of about 60 occupations that qualify under the USMCA. Most of those require the attainment of at least a bachelor's degree or its equivalent, but there are a few exceptions that you'll see on that list. With the TN, there's also no lottery, and there's no cap on the number available. And the other great thing with the TN too is that you can renew the TN indefinitely. You can request up to 3 years at a time. Once that time has run, you can request to continue with that employer or continue your TN employment with a different employer. Next is the F1 option. So OPT, that is your optional practical training. That typically lasts for 12 months. But there is the option for the STEM OPT extension if your major or your field of study qualifies, and that can add an additional 24 months to your status in the US. That allows you the time to prepare for the next years of the H-1B lottery or give you the time to transition to another visa type. Now, if you are on OPT and you have a STEM extension, we recommend that you enter that H-1B lottery every single year to increase your chances, because if you have that STEM extension, you essentially can almost get 3 chances of entering that lottery, and hopefully one of those times you'll be selected. The O1 visa, like I said, this is for those who have extraordinary ability or achievements in the sciences, education, business, athletics, and the arts. You must be able to show that you have some sort of national or international recognition for your achievements and ability. This is a bit of a high threshold to meet, but if you meet the requirements, this is another great option for you. The other that we'll touch on is just the L1 visa. So this is for intracompany transfers who hold either a managerial or executive position. For those positions, you would qualify for an L1A. Or if you have specialized knowledge within your company and field, you could also qualify for an L1B. Now, to qualify for either, you must have worked for the foreign affiliated company for at least 1 year in the past 3 years. And the company abroad must have a qualifying relationship with the US company that you are being transferred to. This is typically shown through org charts that show a similar owner structure between the two companies. The nice thing with the L1A specifically is that there is a direct path to a green card, and that's through the EB1C employment category. And that bypasses that traditional labor certification process, otherwise known as PERM. But keep in mind, this is not the same if you have an L1B. An L1B to green card does require that traditional PERM process.
Sorry, I was unmuting myself there. And for the L1 to take effect, just hitting on that, you would go and work for a Canadian company, for example, for a year. So if you are in a company here in the US and they have foreign offices, that's typically when that would apply. And you can talk to your HR about a potential to be transferred outside of the US, meet that 1 year, and then come back in the country. Cap exempt H-1B options. So for the cap exempt H-1B options, there's a few ways you can meet the cap. One of the most common ways is you are working at a college or university, or an entity that's affiliated with a college or university. And they are what is called cap exempt, as well as nonprofit research organizations or that are affiliated with US government or governmental research organizations. So the companies that or the potential petitioners that actually qualify for cap exempt status are pretty limited, and they are in that field of research and academia and affiliations with those entities and the U.S. government. And if you are working at a private institution that is properly affiliated with one of those institutions, you could still potentially qualify as cap exempt. And we have a client right now who we do H-1Bs for who is cap exempt, and they have an affiliation with a hospital where they place individuals at that hospital who also have, as part of their duties, training students. So they have an affiliation that's close enough with this hospital that also has an affiliation with an institution of higher education that then allows them to place their employees at this hospital under cap exempt status. So sometimes you have to connect the dots to get there, but if a proper affiliation exists, then what this means is they're not subject to the lottery. They can sponsor people throughout the year whenever they need them for an H-1B without going through that lottery process. So if you do find employment with one of these organizations, that can be a big deal for you and skipping out on that lottery. Now, one thing to understand is if you work for a cap exempt employer, your employer meets this cap exempt status exemption, and you don't have to do the lottery. Simultaneously, you can work for a cap subject employer as long as you maintain that cap exempt employment. So how does that work? So let's say you are working at an institution of higher education and I don't know, you have a research job, but then you also have an offer for employment on the side to work for a private company in a role that they need you in. You can take that job without having to go through the H-1B lottery, as long as you maintain your job with the cap exempt employer, and then you can get what's called a concurrent H-1B that allows you to work for both of those employers as long as you're maintaining that cap exempt employment. However, the second you stop working for the cap exempt employer, then your cap subject employer and employment would disappear. So you have to always be working for that cap exempt employer or a cap exempt employer for this to work. Now, this can, however, help you. Maybe you don't want to work for a cap exempt employer, this employer long term. Well, your cap subject employer or an employer on the side can still enter you into the lottery while you're working on a cap exempt H-1B. So this is a potential way to buy you more time if you want to go off into the private sector and don't want to work for a cap exempt employer, for a cap subject employer to keep putting you into the lottery while you're maintaining this cap exempt employment. So it's just another angle, another option where you can potentially work in the United States and not be subject to the lottery, while at the same time try to get into the lottery in future iterations of the lottery. So long term, in most cases, your long term strategy is to move to permanent residency in the United States. And in the United States, there are typically two main options, with the third being self-sponsorship, but two main options to move to a green card. The most common is through what is called the perm process. And the main categories there are the EB2 and EB3 categories under the perm process. And this requires your employer to do what is called a test of the labor market, where they determine whether or not there are willing, able, and qualified U.S. workers in your area of intended employment to fill your role. And if they can't find qualified U.S. workers to take the position, and they present this to the Department of Labor that they've looked out there, that can't find anyone, then what the Department of Labor will do is they will certify their recruitment or their efforts, and then they will allow them to then move forward with a permanent job placement for a foreign national that does meet those requirements. And it allows you to then get a green card based on that recruitment. And that is essentially what perm is called. That's what perm is going through that recruitment process, making sure there are no U.S. workers in the market that can fill this job. And if your employer can show that there aren't, well, then they can move forward and get you a green card based on that. And this is very broad. You can have perm sponsorship for jobs that require a master's, a PhD, years of experience, all the way down to jobs that only require a few years of experience and maybe a high school diploma. So with perm, it doesn't come down to your qualifications that are going to separate you from everybody else. It comes down to the demand for your role and whether or not your employer can find a U.S. worker to fill that role. No matter what the role is, if your employer can prove that they can't find a U.S. worker that meets the minimum qualifications for that role, then that opens the door for your employer to then sponsor you for a green card through that process. The next one is family sponsorship. And this can be limited because the categories that can sponsor you for family sponsorship, they have to be immediate relatives. So if you have an immediate relative who is a U.S. citizen, a spouse, a parent, a child that is over 21, or a brother or sister, they can sponsor you for a green card. Now, if you're being sponsored by a spouse, then it's a relatively quick process. Or if you're being sponsored by a child that is over 21, then that's a relatively quick process. Now, if you're being sponsored by a brother or sister, there can be over a decade wait through that process. So depending on the family relationship, it's going to determine how long the process is going to take to move to a green card. But there are family sponsorship available, even through green cards. So if you are the spouse of a green card holder, for example, or minor children of green card holders, there are some limited categories for green card holders as well. The important thing to understand here is it all comes down to the relationship type that's going to determine how long that process is going to take. Also, not all relatives qualify. We have people ask all the time, they'll say, I have an aunt or an uncle or a cousin. Those relationships don't qualify. Those individuals can't sponsor you for family sponsorship. It has to be an immediate relative, and they have to be a U.S. citizen for the most part. So a spouse, a brother, a sister, mother, father, adult, child. Those are the main categories for sponsorship for U.S. permanent resident sponsorship by a U.S. citizen relative. If you're going beyond that, those attenuated relationships, unfortunately, those ones can't sponsor you. And a lot of those categories are subject to a backlog and long wait times. So you have to, for the most part, if you're being sponsored by family, you have to have an underlying visa if you're going to remain in the United States anyway that allows you to stay here while you go through that process. And the same applies for the perm process. Typically, employers not going to sponsor you for the perm process unless you have an underlying visa that's going to allow you to stay here while you go through that process. So although these are long-term options, typically the long-term option also requires a short-term solution that's going to keep you in the United States while you're going through that green card process. Perm, for example, on average can take, and it depends on what country you were born in. Country of birth plays a huge matter in the green card process. It can take 3 to 4 years, the quickest, and 2 decades, depending on where you're born. So you have to really plan for the long term by having a non-immigrant visa such as the H-1B, TN, or L that allows you to get to that green card step. There's also self-sponsorship options for the green card, and this comes down to people of extraordinary ability. The EB-1A, we refer to that as the Einstein visa. Rebecca talked about the O1. Well, this is a standard even higher than the O1, showing that you are really at the top 1% of your field in the entire world in what you do. And you can show that through achievements, accolades, contributions to your field. If you are in the, have you separated yourself from the rest of your profession and you're at that level, then there could be self-sponsorship. And that's a relatively fast process if you can meet that category. The wait times, because there are so few people that meet that criteria, are relatively short to get to a green card. There's also what is called a national interest waiver. And this is for professionals who can show that their endeavor, what they're doing in the United States, it has a benefit of a broad scope across the entire United States, that the work or endeavor that you're doing is of national importance to the entire United States and the citizens of the United States. For example, and this is probably the easiest example to give, we did a national interest waiver, somebody who worked on civil infrastructure, right? Deteriorating infrastructure throughout the United States, the bridges, the roads, things that are falling apart. Well, that's of national interest that those things are maintained properly. We also did one for an individual who does electric charging for EV charging for electric vehicles, and the technology behind that across the country, which, if you know anything about EV charging, there's a severe shortage in those throughout the United States, and building that infrastructure, that's in the national interest of the United States. So if your endeavor falls within that scope, and it's broad, you can make the argument for whatever you're doing as long as it's in the national interest of the United States and you have an advanced degree. That's another important criteria. You have to have an advanced degree. You have to be able to show that you're well situated and able to move forward that your efforts in the United States in the national interest. Then you could potentially qualify for a national interest waiver. In E2, we did hit on this a little bit earlier. E2, if you want to start your own business and you're going to create jobs for U.S. workers, you could potentially buy or start a business through investment. And the number they give is around $100,000 in creating jobs for at least 3 full-time workers in the United States. Then potentially you could qualify for an E2 visa. There are limits on the E2 visa, however. It does come down to country of birth. And this is where we go back to, it's important to have a discussion with somebody who understands the criteria to determine if that is even an option. If you're not from a country with the right treaty with the United States, then you may not qualify for that E2. But for certain individuals, an E2 might be a good option if you want to go out and do business on your own. We do have a few webinars that we have coming up that might be of interest to you, just to make you aware of them. We will be going over the new alien registration requirement that actually goes into effect tomorrow, April 11th. And that's that 30-day alien registration requirement for those in the United States, and that's through Form G325R. Most people on a work visa in the United States are already registered. If you already have a student visa, a work visa, or admitted with an I-94 to the United States, then you already meet this requirement. This will apply to individuals that enter the United States that were visa exempt, not issued an I-94 when they entered. Also, we'll be discussing TN visas for Canadians and the qualifications for a TN and how to qualify for a TN. Now, do we get any questions? So we didn't get any questions today. So unfortunately, no questions to answer. But if you do have questions that you would like to submit to us, and there is a QR code where you can contact us as well as our contact information. We love answering questions and helping people out with their immigration needs. So feel free to reach out to us if you have questions about H-1B, TN, LE, family-based immigration. We handle all types of immigration here at Richards and Jerusik. So feel free to reach out to us with any immigration questions that you have. And if any of those webinars are of interest to you, we look forward to seeing you at a future time. Thank you for watching and have a great day.